And welcome back to Law and Crime, everybody. I'm Jesse Weber, and thanks for joining us. So we are still following the trial of Jeffrey Lamar Williams, a.k.a. rapper Young Thug, and his co-defendants. Now, remember, the well-known rapper is charged under the racketeering statute, and prosecutors say that the rapper and his co-defendants are part of a criminal street gang known as Young Slime Life, or YSL. The defense is saying that is not the case, that YSL stands for the rapper's record label, known as Young Stoner Life, and that there's nothing nefarious going on here. Well, today, Judge Ural Glanville has paused all matters in the YSL RICO trial until there is a new judge to decide whether he should be removed from the case. And this came after defense attorney Brian Steele caught wind of an ex parte meeting that took place with the prosecution, Judge Glanville, and key witness Kenneth Copeland and his attorney, Kayla Bumpus. Now, Steele believes that the meeting took place because Copeland admitted to the shooting death of Donovan Thomas Jr. So with that, I wanted you to take a moment when Glanville made this announcement earlier today. Let's take a listen.
As then transitioning to the last matter the court wanted to put on record, upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it, and until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until this is, they're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time. Okay.
All right. Well, joining me right now, I have a special guest. I'm joined by attorney Doug Weinstein, who represents Diamante Kendrick, a.k.a. Yak Gotti, in this case. Doug, thanks so much for coming on. No secret, you have been very active in trying to get Judge Ural Glanville removed from this case. You filed multiple motions to have him recuse himself. What was your reaction to today's announcement?
Well, I was surprised that he finally got to this point. It's an announcement he really should have made back on June 12th when I initially filed this motion. He was required at that time to stop the trial, consider my motion, and I think based on the affidavit that I filed and everything else, he should have sent it off to another judge to hear the recusal. So I'm glad he finally got to this point. I'm just sorry that it took, almost 3 weeks to get here, that I had to petition the Georgia Supreme Court and then file another petition in Fulton County last Friday before we got here. Why
do you think he did it now? Do you think there was pressure from some area? Do you think that he was realizing he maybe should have assigned this to a different judge? Why now?
You know, I really can't get into his head and explain why he did that. The only thing that I can guess is that having read the petitions, having considered, perhaps having had counsel from an attorney that would represent him in these petitions for writs of mandamus, perhaps he learned that this is something he should have done a few weeks ago. And I'm glad he finally got to this point because it shortcuts this current petition that I have filed, and we can go right to the main issue or this main side issue, which is, should he recuse himself?
And by the way, do we have any sense of when that decision would come out? I mean, what court it would go to, how the briefing schedule would work, you know, how long the arguments would be? When do you think we could get a resolution of that issue?
Yeah, that's a great question. This is the 4th of July week. The Superior Court here in Fulton County is not going to do anything until he gets his order entered that he referenced today, the order where he is going to send this to another judge for determining recusal. Assuming he gets that in today, then hopefully it would be, Fulton County moves pretty quick. Hopefully it would be assigned to another judge within Fulton County this week or very early next week. I don't think a judge in Fulton County, though, can actually consider this recusal issue.
And explain to us why, because there's a conflict?
Yeah, I mean, I think that if you look at the case law in Georgia, and in particular, there's an opinion from the Georgia Judicial Qualification Commission who kind of governs the judges here in Georgia, that a judge within a particular circuit cannot hear another case involving a judge in that same circuit. So I think whatever judge ends up with this in Fulton is going to have to end up recusing themselves and sending it off to another circuit, or it's going to have to be sent off to another circuit.
And for our viewers who don't know why is it you're asking for Judge Glanville to recuse himself at this point in time?
Well, you know, the motion that I filed and presented to the judge on June the 12th is a little different than the one that Brian Steele filed the following week. The reason that I'm asking for a recusal is because specifically of the ex parte hearing that he held with Mr. Copeland without us present, without our knowledge, where there seemed to be an attempt to keep it secret from us, given his attitude and how he acted from the bench once he found out that we learned about it. So the conduct of that ex parte hearing, what happened within the hearing, and then you add on to that the fact that he did not take the actual recusal motion and follow the rule on that. So there's a couple of violations, I think, of the Judicial Code of Conduct that would merit his recusal just within this, just within that week, just on the 10th and the 12th. I believe you'll have to look at Brian Steele's motion. I think he complains of more than that, but Brian's treatment in court has been different than my treatment in court.
Can we talk about that for a second, your treatment in court? Because you had a very interesting back and forth with Judge Glanville. And correct me if I'm wrong, you said, are you not concerned about, or do you have any interest in removing the cloud over this case? And Judge Glanville basically responded to you and said, basically be careful with what you're saying. What did you mean by that? And what did you take away from Judge Glanville's response?
Well, I believe he quoted Walter White from Breaking Bad to me, and he said that he reminds me of my professional responsibilities and that I should tread lightly. My intent on telling the judge that, or suggesting to the judge that perhaps giving me a certificate of immediate review so that an appellate court could review his decision on my recusal motion might be good, because I did believe, and I still believe, that there's a cloud that's been cast over this case due to that ex parte meeting that he held. And yeah, he was not happy with me about that, and did tell me to tread lightly. But I have obligations to my client, so I represent Diamante Kendrick with Katie Hingerty and with Jay Apt. He may tell me to tread lightly, but I have to do what's in my client's interest, and it's certainly in Mr. Kendrick's interest to remove the judge based on his actions in that ex parte meeting that he held.
The Judge Glanville, responded also by saying that this was just about you didn't like his ruling, and that if there was ever a case where attorneys disagree with the judge's rulings, then they immediately would be able to file recusal motions. That's the way that he characterized it. What did you make of that?
It is the way he characterized it, and we've been in trial for 18 months, and if I wanted to ask for recusal, or if any of us wanted to ask for recusal based on rulings that have gone against us, we could have done it scores, maybe hundreds of times over the last 18 months. It was a mischaracterization of the motion. I don't know why he put it that way. I attempted to correct him in court, which you can see, but that was the position that he took. He did somewhat change that in the written order that issued 2 days later. But again, I think that written order had errors in it as well. So I don't know why he characterized it that way from the bench. I was not complaining about any particular order that he gave or any rulings that he made. I was complaining of conduct, and I'm still complaining of conduct.
And let's amplify that a little bit, because one of the allegations is that in this ex parte meeting, that Judge Glanville essentially, and this has been put forward by Brian Steele, intimidated Copeland and said that you have to testify because Copeland was resisting to testify. And then Copeland had suggested that he was going to go take the stand and say that he was involved in the shooting death of Donovan Thomas. Do you believe that Judge Glanville engaged in witness intimidation?
Well, if you read my motion that I filed on the 12th, I have an affidavit there, and I have the same source as Brian Steele, and that source told both of us that Judge Glanville was involved with the prosecution in coercing Kenneth Copeland to testify. And that is just not appropriate conduct from the judge. Now, the judge is not in a position to refute that, at least on considering my motion to recuse. If he wants to refute that later, perhaps the transcript will show that my source was completely wrong. But again, that's why I've been asking for the transcript. And in the written order that the judge gave us on the 12th of June, he doesn't really deny what I state in my affidavit, which is the same as pretty much as what Brian Steele said in court. He doesn't really refute that in the order. He just says that I lack additional evidence to support that affidavit. But of course, how can I have that evidence if he's refusing, at least at that time, providing the transcript?
How do you think Judge Glanville's been doing overseeing this case, which is a massive case, very complicated case, over almost a year of jury selection? What's your views on how he's presiding over this trial?
Well, I think that he's in a very difficult position. It's a very complicated, complex case that the state has brought. I think he's been trying hard. I think he's been trying to do his best. I believe that I suspect he believes that he's making rulings that are unbiased. And I have tried to believe that that's really the case. But after what I learned occurred in chambers on June the 10th, I'm going back now and questioning a lot of my beliefs. But up until that time, I really didn't believe that he was making his best efforts to handle a very complex and unwieldy case brought by the Fulton County DA's office.
I imagine that you will echo a lot of legal commentators who took issue with Brian Steele being essentially held in contempt of court if the Georgia Supreme Court didn't step in. When that happened, what was your reaction that Judge Glanville was going to hold him in criminal contempt for not revealing the source of the information, for not revealing how he knew about the ex parte meeting? That's why he was held in contempt of court.
I was shocked that the judge would have done that. I think you've heard from people, I'm sure you've heard from people about Brian Steele's absolutely sterling reputation for integrity and professionalism. And maybe the last lawyer I could ever imagine being in contempt of court would be Brian Steele. So having seen him held in contempt, I was just stunned by that. And I kind of believed it was an effort by Judge Glanville to deflect from his conduct during the morning of the 10th in that ex parte hearing and change the focus onto Brian Steele. Where did you learn of that information, Mr. Steele? That's not really the issue, and that's not the issue that Brian was bringing up. Where he learned of it isn't important. What's important is what happened in that meeting.
Mm-hmm. And let's just finalize it on this point. If another judge, whether it's from a different county or whatnot, decides that Judge Glanville should recuse himself, what is going to happen with this trial? Does it start from all over again? Do you start from jury selection? What do you think is going to happen if that happens?
Well, I can tell you what the law says on a trial where you have a recusal of a judge, which is in Georgia, if there's a recusal of the judge, you're supposed to essentially rewind the case to the point where the judge should have recused himself. When I presented the judge with my motion on the 12th of June and he denied it, at that point, what he was supposed to do was do what he did today, which is send our motion to another judge. He failed to do that. So you have to rewind to that point. I don't see how a new judge unwinds the case to June the 12th. If memory serves me and my notes are correct, the jury has heard evidence from Copeland. There have been arguments. There have been rulings from the judge. How do you unwind this case to June the 12th? I don't see how you unwind this case. How does the jury unhear the testimony from Copeland that they heard? I think it's very difficult to rewind the case at this point.
Wow. Doug Weinstein, Diamante Yakgati, Kendrick's attorney, thank you so much for coming on. Really appreciate you taking the time. Thank you. It's been an illuminating conversation, trying to see what happens. Yeah, no, of course. And we're going to keep everybody posted with the new happenings in that Georgia courtroom as it goes on.